When I was appointed to this position last fall, I committed to the residents of Maricopa County to enhance and ensure transparency in this office. Today, I am formally announcing my decision in the shooting death of Antonio Arce, which occurred on January 15th, 2019, by Tempe police officer Joseph Hine. Understandably, this case is of great significance to the community, and this public announcement demonstrates my commitment to transparency in decision-making. It is my role as county attorney to review the circumstances surrounding critical incidents involving first responders. Some examples of incidents include an officer-involved shooting, a death that occurs while a person is being arrested or in custody, or an incident such as a traffic collision where serious physical injury or death occurs. When these situations arise, it is the responsibility of this office to review and analyze the facts and evidence as submitted to us by law enforcement. We review the facts as an independent charging agency to ensure that the due process rights of a potential criminal defendant or a potential victim are protected. Let me be very clear. The decision today by the Maricopa County Attorney's Office is to determine if criminal charges should be filed in the shooting death of Antonio Arce. Our decision in this matter has nothing to do with whether or not there is civil liability in this case. Our decision does not pass judgment on whether departmental policies and procedures were followed in this matter. Those matters are left to civil courts and municipal administrative bodies. Again, our review and findings in this case are limited to criminal charges and the likelihood of conviction at trial should charges be filed. Before I go any further, I want to acknowledge the loss of life in this case. To Antonio's family, I am deeply sorry for your loss. We do not rush to judgment in review of these cases. The process undertaken by this office in reviewing this matter was extensive, and over the last several months, numerous investigators, prosecutors, and other staff reviewed transcripts, body-worn camera footage, examined photos, and other pieces of evidence. Every single person who played a role in this did so professionally and with great care. It is my understanding that the Tempe Police Department has released the majority of the evidence in this matter, including the body-worn camera footage, so many of you have seen what we reviewed. As county attorney, I also decided to seek an expert analysis of the evidence. I wanted a review that was independent from the Tempe police investigation that would provide an opinion from an impartial third party. This report, authored by James Borden, was submitted to us on December 31st of 2019. This was another piece of information that helped guide my decision in this case, and you will be provided a copy of that report. The key to our decision-making is whether or not we can prove a crime was committed and if we think a jury would convict based on that evidence and the law. Two U.S. Supreme Court cases are especially relevant when analyzing use of force incidents. Tennessee v. Garner says, and I'm going to read this verbatim, where the officer has probable cause to believe that the suspect poses a threat of serious physical harm, either to the officers or to others, it is not constitutionally unreasonable to prevent escape by using deadly force. The 1989 decision in Graham v. Connor outlines a three-pronged test when determining the reasonableness of lethal force. The direction from the court in that case is embedded in police officer training nationwide. It provides guidance to police agencies on whether lethal force is reasonable based on three factors. First, the severity of the crime at issue. Second, whether the suspect poses an immediate threat to the safety of the officer or others. And third, whether the suspect is actively resisting arrest or attempting to evade arrest by flight. Our own state statutes say that police officers are justified in using deadly force when the officer reasonably believes that it is necessary to defend him or herself or a third person from imminent danger. Based on the facts and the evidence in this case, Officer Hine believed that he was in imminent danger. Officer Hine believed that those in the immediate area were in imminent danger, and that Officer Hine believed he had no other choice but to fire his weapon to protect himself and the community. In a court of law, the state must prove their case beyond a reasonable doubt. In order to even file charges, attorney ethical responsibilities are that prosecutors must believe that there is a reasonable likelihood of conviction at trial. The events of January 15, 2019 forever changed the lives of many. And this situation is absolutely heartbreaking. But that day, Officer Hine did not see a 14-year-old boy with a replica. In that moment, he saw a suspect running through a neighborhood with a weapon. In those few split seconds, Officer Hine believed that someone was fleeing the scene of a crime, that they were in possession of a handgun and holding it in a manner where the weapon could be easily discharged. Combined with the fact that Antonio was about to turn a corner in a neighborhood, Officer Hine would have no longer had Antonio in his sights, and Officer Hine would have no way to protect the innocent residents in their homes that day. Therefore, I do not believe the evidence in this case supports a likelihood of conviction at trial, and this office will not be filing criminal charges in